The 5-year regulation enables the government to claim your residence, and the majority of older adults remain unaware until it has become much too late to take any action regarding it. If you are 65 or older, if you possess your residence, if you maintain any retirement funds whatsoever, you must comprehend precisely the way this regulation functions, because the individuals who are expected to describe it to you possess a very powerful incentive to remain silent. There exists one particular paperwork that can halt the complete procedure before it ever commences. But most estate lawyers will not raise it unless you request it using its exact title. I will reveal what that paperwork is named before this video concludes. The regulation itself is known as the Medicaid 5-year lookback, but the title is deceptive. It is not truly about reviewing the past. It is about penalizing you for actions you took when you had no notion you were committing any error. Here is the manner in which it operates. If you ever require extended nursing facility assistance, and the average duration in this nation currently costs over $18,000 per year, you will very likely exhaust your funds. Consequently, you will need to request Medicaid to cover the expense. But prior to Medicaid disbursing even $1, a state caseworker will retrieve every bank record, every real estate file, and every present you have provided for the prior 60 months, every individual movement, every payment to a grandchild, every vehicle you assigned over, every dollar you relocated. Then they compute a sanction. The sanction is not a monetary charge. It is something more severe. The state takes the complete sum you moved during those 60 months, separates it by what they refer to as the regional sanction divisor, which in most states rests between $10,000 and $12,000, and the outcome is the quantity of months you are barred from Medicaid support. Throughout those months, you must cover the nursing facility yourself at over $9,000 per month, even though the complete purpose you requested Medicaid is that you lack $9,000 per month. This is the snare. You distributed the funds. Consequently, you cannot cover it. But since you distributed the funds, the state will not cover it either. So, who covers the nursing facility? The nursing facility does not mind. They will take legal action, and the initial resource they will pursue is your residence. Most individuals suppose the regulation merely captures big movements. That is incorrect. The look back captures all of it. A $400 Christmas payment to your granddaughter counts. Covering your son's marriage ceremony counts. Assisting a grandchild with university fees counts. Canceling a debt to a relative counts. Selling your vehicle to your nephew for $1 counts. Even philanthropic contributions above a specific limit can count according to the state. There is no birthday exclusion. There is no holiday exclusion. There is no "I was unaware" exclusion. The federal yearly gift tax allowance, which currently rests at $19,000 per recipient, has no connection to this. That is an IRS regulation. Medicaid is an entirely distinct framework with its separate regulations. And Medicaid does not mind what the IRS permits. A present that is entirely lawful under federal tax legislation can nevertheless activate a complete Medicaid sanction. Most older adults do not grasp this difference. Consequently, they suppose their presents are secure. They are not. Now, here is where it becomes more serious, and this is the section that ruins partnerships from beyond the grave. If you are wedded and your partner enters a nursing facility, you may suppose the law safeguards the well partner who remains home. There is a safeguard. It is known as the Community Spouse Resource Allowance, and in 2026, it rests at $157,920. That is the highest quantity of countable resources the at-home partner is permitted to retain. Everything beyond that figure must be expended before Medicaid will pay 1 cent. $157,000 appears like a great deal until you understand what it actually must cover. Property taxes, home maintenance, Medicare payments, food, fuel, prescriptions, emergencies for the remainder of the well partner's lifetime, which could be 20 years, which calculates to roughly $657 per month. That is the calculation the state anticipates you to survive on while your husband or wife is in a facility that is billing over $9,000 per month for the identical time frame. But the residence? Surely the residence is secure. The residence is the one item they cannot access. That is what nearly every older adult in America supposes, and it is incorrect. The residence is excluded while you are living and utilizing it. Consequently, Medicaid will not compel you to dispose of it before you become eligible. But the instant the Medicaid beneficiary passes away, a program named the Medicaid Estate Recovery Program activates. Federal legislation requires every state to seek to reclaim the expensive assistance from the estate of any Medicaid recipient who was over 55 at the time benefits were provided. The recovery focus is the residence. The state submits a claim against the estate. The heirs are informed they must either settle the bill completely, often hundreds of thousands of dollars, or dispose of the home and hand over the earnings. The average estate recovery claim in this nation now surpasses $74,000. In some states, it is over $200,000, and it is not voluntary, it is not flexible. The federal government requires the state to pursue the residence. Consequently, the residence your parents assured would pass to the grandchildren ends up passing to the state of wherever they happen to reside. And in 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, there is an even older regulation on the books called filial responsibility. These regulations state that grown children can be held financially accountable for the unsettled nursing facility bills of their parents. For decades, these regulations sat unused. But beginning in 2012, after a Pennsylvania appeals court decided that a nursing facility could collect $93,000 from an adult son for his mother's assistance, the floodgates opened. Consequently, the snare is not just that the state claims your residence. The snare is that the nursing facility, after the state completes its recovery, can turn around and sue your children for whatever remains. I will provide you a genuine example. A widow in Ohio, age 78, moved $45,000 to her daughter over a 4-year period. Birthday presents, holiday payments, some assistance with a vehicle repair, nothing she regarded as unusual. She entered a nursing facility in month 47 of those 4 years. The state divided her $45,000 by the Ohio-sanctioned divisor of $7,163 per month and barred her from Medicaid for 6 months. The nursing facility billed her $9,200 per month for those 6 months. Total bill $55,200. She did not possess it. The facility placed a lien against her residence. She passed away 8 months afterward. The state then submitted an estate recovery claim for an additional $140,000 in care expenses. Her daughter received a letter informing her that the home she grew up in was being sold by court order. There is a method that some lawyers employ to reduce the impact when there is no time remaining. They call it the half a loaf. The concept is that if you or your partner already requires assistance, you distribute half of your remaining resources and utilize the other half to cover assistance during the sanction period that the gift creates. It preserves something. It is preferable to forfeiting everything, but it demands exact timing. It demands a specialized lawyer, and it has to be completed before the Medicaid request is submitted, not afterward. Once you request, the method is finished. The older adults who forfeit everything are almost never the ones who prepare. They're the ones who were never informed. Preparation was an option. They sat in a hospital room, signed a power of attorney, and started writing payments to the nursing facility with no idea that with one phone call to the proper type of lawyer 2 years earlier, they could have safeguarded the residence, the retirement funds, and the legacy. Now, I informed you at the beginning that there is one paperwork most estate lawyers will not raise unless you request it. Here is what it is named. It is called a Medicaid Asset Protection Trust. In 5 specific states, including Florida, Texas, Michigan, West Virginia, and Vermont, there is also something called a ladybird deed, which achieves part of the identical purpose for the home. Specifically, a Medicaid Asset Protection Trust is an irrevocable trust. You transfer your residence, your retirement funds, and your investments into the trust. You no longer officially possess them. The trust does, but you can still reside in the home. You can still obtain the earnings from the investments. You simply cannot remove the resources back out after the trust has been established for 5 years. Those resources are no longer counted by Medicaid. The lookback cannot access them. The Estate Recovery Program cannot access them. The residence is safeguarded. The retirement funds are safeguarded. Everything inside the trust passes straight to your heirs without proceeding through probate, without proceeding through estate recovery, and without being accessed by the state. The reason most lawyers do not mention this is straightforward. A Medicaid Asset Protection Trust costs between $4,000 and $12,000 to establish properly. A standard will cost $200. The older adult walks in requesting a will. The lawyer sells them a will, and the discussion about extended care never occurs. Consequently, you must walk in already knowing the correct phrase. You must speak the words Medicaid Asset Protection Trust out loud, and you must inquire whether you qualify, and you must do it at least 60 months before any assistance is required because the 5-year timer does not commence until the trust is funded. Here is what to do this week. First, retrieve every bank record from the last 60 months and search for any movement over $500 to a family member. Create a list. You need to know your risk before you speak to anyone. Second, locate a lawyer who is certified in elder law specifically. The certification is called CELA, which stands for Certified Elder Law Attorney. A general estate lawyer is not sufficient. You need someone whose complete practice is constructed around Medicaid preparation. Third, inquire that lawyer by name about a Medicaid Asset Protection Trust. And if you reside in Florida, Texas, Michigan, West Virginia, or Vermont, also inquire about a ladybird deed for the home. Fourth, obtain the trust funded right away because every day you delay is a day added to the back end of your 5-year timer. Fifth, inform every grown child in your family to read this exact same information because the regulation does not just impact you. It impacts everything you plan to leave behind. The 5-year timer commences the day the trust is funded, not the day you decide to prepare, not the day you contact the lawyer, the day the resources actually transfer. Consequently, the most costly day in your life is the day after you should have begun.